Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
And today, the Supreme Court has answered that question by a vote of 6-3.
Justice's ruling this morning, it conflicts with the Second Amendment's right to bear arms.
God, how cool is it?
A single notice appeared on the Supreme Court's website at exactly 10:01 in the morning. No advance warning, no press conference, no political theater, just a brief posting that would fundamentally alter who can purchase firearms in America. Within minutes, legal experts across the country started making urgent phone calls. Within hours, lawmakers were issuing panicked statements. And within days, the entire architecture of federal gun regulation found itself standing on crumbling ground. This was a 6-3 decision, the kind that reverberates through history long after the judges who wrote it are gone. For decades, federal law meticulously controlled who qualified to own a firearm. Background checks, waiting periods, mental health evaluations, disqualifying offenses, layer upon bureaucratic layer of government approval standing between citizens and their constitutional rights. But this new ruling cuts straight through that system like a knife through paper. It fundamentally challenges whether Washington possesses the authority to decide who qualifies to defend themselves. The ruling has lawmakers absolutely furious and millions of gun owners stunned and confused about what just changed. Because if the court got this right, if their legal reasoning holds, then a massive structural pillar of gun regulation just collapsed today. And before the media spins this story into complete chaos and political noise, you deserve to understand what actually happened and what it genuinely means for your rights. So let's trace exactly how we arrived at this explosive moment. To understand this 6-3 decision that's shaking the foundations of gun law, we need to go back to where the earthquake actually started. Back to the case that rewrote the entire constitutional playbook on Second Amendment rights. New York State Rifle and Pistol Association versus Bruen, June 23, 2022. Most Americans barely noticed when the decision dropped, but inside the legal system, the ground fundamentally shifted beneath everyone's feet. On that day, the Supreme Court didn't simply rule on New York's concealed carry permit scheme, they demolished decades of established judicial reasoning in a single opinion. And what they replaced it with was constitutional dynamite with a slow-burning fuse. For the first time in modern jurisprudence, the court declared explicitly that the Second Amendment is not a government-granted privilege subject to political whims. It's a constitutional guarantee that must be evaluated through the lens of history, not contemporary policy preferences or safety concerns. Then came what legal scholars now call the Bruen Standard, and this is where everything changed.
The right to keep and bear arms shall not be infringed.
This case could reshape how far states can restrict your right to carry and where.
From that moment forward, every single gun law in America had to be justified by demonstrable historical tradition. If a modern restriction couldn't point to a clear historical analog from the 1700s or 1800s, it had no constitutional legitimacy. Think about the implications for a moment. The entire sprawling federal and state gun control apparatus suddenly found itself on trial against American history itself. And here's the twist that nobody anticipated. Overnight, the constitutional burden of proof completely flipped. Citizens no longer had to justify their rights or prove they deserved government permission. Now the government had to prove its restrictions had legitimate historical foundations. That reversal opened the floodgates immediately. From California to Delaware, lawsuits started flooding into federal courts. Thousands of pages of legal briefs citing Bruen as the constitutional sword that would slice through decades of accumulated restrictions and red tape. Courtrooms that had routinely dismissed Second Amendment challenges suddenly began hesitating, reconsidering, and eventually reversing course. One federal judge wrote in his opinion that this ruling has set in motion a constitutional reckoning unlike anything we've seen in gun law. He wasn't exaggerating or being dramatic, because every crack that appeared in gun control statutes led directly here, to 2025, to the ruling that finally detonated what Bruen started. The decision that has lawmakers scrambling and gun owners asking the same urgent question. If the Supreme Court just fundamentally changed who can purchase firearms, what happens next to the entire regulatory system? To find that answer, we need to examine where the first domino actually fell. A small state with an enormous case, Delaware, where the chain reaction truly began. Delaware became ground zero, and it didn't start in Washington with grand political gestures. It started in a modest courtroom in Wilmington. No television cameras, no media circus, just a handful of attorneys, a few local reporters, and a state law that was about to crumble under constitutional scrutiny. Delaware had enacted legislation restricting firearm purchases for anyone under 21 years old. State lawmakers justified it as a public safety measure, keeping guns away from young adults who supposedly lacked judgment and maturity. But the plaintiffs, two 20-year-old Delaware citizens, presented a fundamentally different argument. They said if we're legally old enough to vote in elections, old enough to pay taxes, old enough to serve in the military and potentially die for our country, why are we considered too immature and untrustworthy to defend ourselves? That single question, elegantly simple and brutally honest, became the spark that ignited everything that followed. Their attorneys came armed with one primary constitutional weapon, the Bruen Standard. They systematically argued there existed no historical tradition whatsoever of prohibiting 18 to 20-year-olds from owning firearms. When the state attempted to justify the restriction using modern crime statistics and contemporary safety data, the judge stopped them immediately. Under Bruen, he stated clearly, modern policy concerns cannot override historical constitutional rights. The courtroom went completely silent, because in that moment, a state law fell. The judge ruled definitively that Delaware's age restriction violated the Second Amendment's historical protections. Just like that, one domino tipped over and crashed to the ground. But what nobody in that courtroom fully realized was that Delaware's quiet decision wasn't the conclusion of a legal fight. It was the opening shot in a nationwide chain reaction. Other states immediately took notice. California, Illinois, New York, each had implemented similar age-based restrictions. Each one suddenly looked constitutionally vulnerable under the new analytical framework. And inside the Department of Justice, alarm bells started ringing loudly. Federal attorneys privately warned that if these state laws kept falling one after another, entire sections of federal gun statutes could collapse next in the domino chain. That's when the stakes exploded far beyond Delaware's borders. Government lawyers realized that if the Bruen historical test kept spreading through the courts unchecked, the fundamental definition of who qualifies to purchase firearms in America would be completely rewritten, and they absolutely weren't going to let that happen quietly or without a fierce legal battle. Behind closed doors in Washington, new test cases began forming strategically, cases specifically designed to halt this constitutional momentum in its tracks. But instead of stopping the movement, one of these cases would do precisely the opposite. It would push the Bruen logic even further and force the Supreme Court to directly confront a question nobody in power wanted definitively answered. Who actually decides what constitutes dangerous? The government with its modern data and policy preferences, or historical constitutional tradition itself? That constitutional battle began 3,000 miles away in a state internationally notorious for gun laws so complex and restrictive that even law enforcement officers struggle with the bureaucratic paperwork. California, the next major battlefield in the escalating war over who gets to purchase firearms in America. California doesn't just regulate gun ownership through laws, it regulates the very concept and idea of ownership itself. Every single sale tracked, every permit scrutinized, every bullet accounted for in government databases. To purchase ammunition in California, you don't simply show identification and pay. You undergo a complete background check every single time you buy. On paper, proponents argue it sounds like reasonable safety policy, but in actual practice, it transformed millions of law-abiding citizens into presumptive suspects requiring constant government vetting. Consider the absurdity. You want to buy ammunition for a weekend shooting range trip, and suddenly you're flagged as prohibited because a government database contained a typo in your name or outdated information. That's not a hypothetical scenario. That's exactly what happened to thousands of legal California gun owners. They suddenly failed background checks for purchasing ammunition. Some waited weeks to get clearance and corrections. Others simply gave up entirely out of frustration. The system didn't just delay constitutional freedom, it actively denied it, whether by intentional design or bureaucratic dysfunction. Then came Kim Rhode, an Olympic gold medal winning shooter with an impeccable record. She took California to federal court, arguing persuasively that the state had systematically transformed a fundamental constitutional right into a government-controlled privilege requiring constant permission. Her case, Rhode versus Bonta, became the legal powder keg everyone had feared since Bruen. When the legal dust finally settled, the federal judge didn't mince words or hide behind careful judicial language. He called California's system unconstitutional, excessively burdensome, and completely lacking historical foundation. He cited Bruen extensively, declaring that the state's elaborate regulatory scheme had no legitimate historical analog whatsoever. Translation: American history didn't support California's approach, and if history didn't back California's comprehensive gun control system, it might not constitutionally support anyone's restrictions. That judicial ruling sent absolute panic rippling through gun control advocacy circles nationwide. For the first time since Bruen established the new test, an entire state's gun control framework, not merely a single isolated law but a comprehensive regulatory system, had been systematically dismantled in federal court. Lawmakers scrambled desperately. Emergency appeals were filed within hours. Federal attorneys practically begged the Supreme Court to intervene immediately before the legal precedent spread to other jurisdictions. But the Supreme Court didn't rush to halt the momentum. They observed carefully. They waited strategically. Because behind the public scenes, another case was steadily moving toward their docket. A case that wasn't about ammunition or permits at all, but about legal liability and blame. A case that would test whether gun manufacturers themselves could be held legally responsible and punished for crimes they absolutely didn't commit. That case would drag not just one company, but the entire American firearms manufacturing industry into the constitutional fight. It's called Smith & Wesson versus Mexico. And when that case hit the Supreme Court's docket, the justices could no longer remain silent observers. They had to decide. When Mexico's government sued American gun manufacturers, most legal observers initially dismissed it as symbolic political theater. But inside federal courtrooms, the case became something far more constitutionally dangerous. Smith & Wesson versus Mexico claimed that United States gun makers bore legal responsibility for cartel violence occurring south of the border, that their product designs, marketing strategies, and even advertisements directly fueled criminal activity and drug war deaths. If that legal argument succeeded, the implications wouldn't just target corporate defendants. It would tear through the foundational logic of the Second Amendment itself. Because if gun makers could be held liable for the criminal actions of third parties they never met, how long before individual gun owners faced similar liability theories? That question haunted the justices. When the Supreme Court finally ruled 6-3, it wasn't merely a verdict in a single case. It was a constitutional declaration with sweeping implications. The majority held that liability cannot cross international borders, not for companies and definitely not for constitutional rights. The decision sent shockwaves through legal communities. But buried deep within the majority opinion sat a single paragraph that quietly redefined the constitutional limits of federal power over gun purchases in America. A paragraph that changes everything moving forward. That's it for today, folks. See you in the next video.